Hello, everyone. It's Pam Esquire, also known as your law intellect. I see you guys are chit chatting in this here chat. I mean, we are like one big happy intellectual family over here. So I want to speak to everyone, well, as many as I can. CBBJ, some of y'all been waiting for a minute, huh? Want this good update here? I didn't think I was going to be able to go live because we lost power for a minute. But as soon as I just was going to throw in the towel, the lights came on. So now we are going live so we can get some updates today. It just was not a good couple of weeks for the bishop in the court. I mean, deny, 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 and deny. Hey, CBBJ. Hey, LaFrance. Giger, Frazier, Angie, Jackie. Sweet Nectar 58, Ray Mail. What's up? Narco detective said, oh, yes, the old boy was acting up because the judge ruled on those motions. The New Yorker ran that same article today he was ranting about. They had a new article that came out today. Y'all, send me the article. Let me see if I can find it before we get started here. We have a few things to go over. You know how we do. We go with the documentations, or some people refer to as receipts. That's what we do over here. Let's see. I didn't even see any articles if any of them came today, but I was on those court documents today that were filed. I don't see it. Hey, Shelly, NFL wife. Hey, welcome her. That's one of our newer mods that we have on here. Alice, good to see you. Poetic Mouth, good to see you. All right, y'all all in the house. It's 173 of y'all up in here. I need you to hit that like now. It's free. Show that you appreciate everything that goes on over here. Show that you love me. Hit that like button. If you haven't done so already, make sure that you subscribe to the platform. We appreciate it. Hey, I can't even speak to Antoine. All y'all. Thank you. You said to read the article. Oh, you're talking about the old article, maybe. Okay. So we got a couple of things that we're going to have to discuss here in the court. We're going to have to ask Whitehead to come and to approach the bench because we have some documents that have come down, some responses that have come down. If you guys recall, when you all were asking me what was going on in his case, the criminal case in federal court, and I was like, he just filed a bunch of motions, and I don't really understand why these motions were filed, but we went over one of them, right? But the other ones, and that one just was to give you a preview of what these motions were looking like. I didn't understand why these motions were filed. It didn't make no sense to me. So I didn't even really go over them. I just told you he filed a bunch of motions. Well, of course, he filed 4 motions. We went over one, and the government had to reply 2 weeks ago. Well, today an order came out where the judge has ruled on these motions that were filed. And then after we go over the judge's order, we're going to do an update on Pauline Anderson, which started all of this. If you guys have been following my platform when we first started going over the cases of Whitehead, Pauline Anderson is one of the people in the indictment over the $90,000. So there was an update on that a couple of weeks ago, but the paperwork was just coming and coming and coming, and we didn't have time to go over it. So we're going to go over that today. So let's get started. Hey, get in the curse. Thank you for coming over. Maria, thank you. So I could talk to y'all all day, but I want to get to this. So this is an order that came down today. Let me take myself off of here. So this is the order that came down today, and we're going to read over it, and it kind of gives us a summary of what was filed by Whitehead. So then we don't have to read those motions, because the motions honestly were so convoluted that I really didn't even want to read it on here. But this will give us a summary and what the judge's order was. So it starts out, whereas on January 17th, 18th, 19th, and 20th, didn't I tell you guys he was filing a motion almost every day? You see that 17th, 18th, 19th, and 20th of 2023, defendant Lamor Whitehead filed the following 4 motions. Number 1 was an emergency, and they put it in quotes, motion for a special order pursuant to Local Criminal Rule 23.1H2, a motion to identify witnesses with juvenile adjudications and pending juvenile proceedings and to inspect juvenile files. The third motion that was filed was a motion for a notice by the government pursuant to Federal Rules of Criminal Procedure 12 of its intention to use specific evidence arguably subject to suppression. And 4, a motion for pretrial production of evidence admissible to attack the credibility of Brandon Belmonte. So we went over the first one, I believe it was, that emergency motion, and we went over his motion and also the government's response. So the order starts out with, whereas pursuant to the order dated January 20th, 2023, the government filed a response in opposition to each of the above motions on February 3rd, 2023, whereas defendant did not file a reply before the deadline of February 10th, 2023, it is hereby ordered that defendant's motions are resolved as follows. As to the first one, defendant's January 17, 2023 motion for a special order pursuant to Local Criminal Rule 23.1 is denied. Local Criminal Rule 23.1A prohibits lawyers as well as government agents from releasing or authorizing the release of non-public information or opinion to the public in connection with pending or imminent criminal litigation with which they are associated, if there's a substantial likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. We went over that motion. Rule 23.1H provides that courts may issue, quote, special orders governing such matters as extrajudicial statements by parties and witnesses likely to interfere with the rights of the accused. Rule 23.1H requires that in doing so, a court shall consider whether such an order will be necessary to ensure an impartial jury and must find that other less extreme available remedies, singly or collectively, are not feasible or would not effectively mitigate the pretrial publicity and bring about fair justice. So basically what he was saying in a nutshell was, he was trying to say, because of the statement that came out by the FBI when they did the press release, or by the federal government when they did the press release, and the agent. And then that article where Belmonte talked about him, they said that basically those statements can sway a jury because your jury is obviously the public. So that's really the gist of their argument. Defendant seeks relief based on statements made by in a press release announcing his arrest by U.S. Attorney Damian Williams and FBI Assistant Director Michael Driscoll, and by a private individual named Brandon Belmonte. None of the relief defendant seeks is necessary to prevent any of those individuals' past or future statements from infringing defendant's right to a fair trial, as explained below. So let's go over the statements. The court was very specific on going over all of the different people. So statements of U.S. Attorney William and FBI Assistant Director Driscoll. None of the statements attributed to U.S. Attorney Williams or FBI Assistant Director Driscoll in the government's press release violates Rule 23.1. The press release contains an unremarkable recitation of, quote, the nature, substance, or text of the charge, including a brief description of the offense charge and substantially the terms used in the indictment. Williams is quoted paraphrasing the charges using the words, quote, absurd, abused the trust, end quote, in place of defrauded, and bullied, quote, instead of attempted to extort. Driscoll is quoted characterizing the alleged fraud and attempted extortion as duplicitous schemes and the alleged false statements to federal agents as consciously choosing to mislead and lie to them. The use of such near synonyms does not constitute an opinion as to defendant's guilt or innocence or as the merits of the case or the evidence in this case. Well, at the end of the press release, too, it also says that everybody's innocent until proven guilty. I mean, it's like plastered on there. But nevertheless, particularly when prefaced by the qualifier, as we allege today, and they put as we allege today. Similarly, Driscoll's general statement that the FBI will pursue others who would attempt to obtain funds through false promises or threats is an unobjectionable statement of the FBI's mission. Similar summaries of allegations contained in an indictment have been approved by other courts. These are the cases, if you guys are so inclined to look those up. Taking issue with statements that appear to bundle together unproven allegations regarding the defendant with broader commentary on corruption, but noting that the government may discuss the facts of a case, the offenses charged, and even the public policy significance of a case to the extent that such discussion is in furtherance of law enforcement goals. So what is in parentheses, you guys, are basically the summary of what these cases, if you were to look them up, would say. So the statements by Brandon Belmonte, defendant also seeks relief from Brandon Belmonte's statement to a journalist that appeared in the article in the New Yorker. That's the article that he told all of you guys to go to on his live the other day to that he thought somehow helped him. I don't know. At least some of Belmonte's comments presumptively violate Rule 23.1 because they pertain to the character or reputation of defendant and express opinion as to defendant's guilt. However, even assuming for the purpose of this motion that Belmonte is a government agent, at least to some extent and at some time, this motion fails. Defendant has not shown that an order restricting Belmonte's speech is necessary, given that, quote, other less extreme available remedies would effectively mitigate any prejudice to defendant, and has the local criminal rules and the United States v. Gotti as the case. And let's go forward. The government represents, based on discussions with Belmonte's counsel, that Belmonte has no intention of making further statements to the press about this case. While this assurance may not moot the motion entirely, there is no reason to think at this time that ordinary trial management tools will be insufficient to mitigate any risk to juror impartiality, including, quote, searching voir dire and empathetic jury instructions. So that is the first motion. Oh my goodness. So we'll go on to the second motion. So the second motion says Defendant's January 18, 2023 motion to identify witnesses with juvenile adjudications and pending juvenile proceedings and to inspect juvenile files is denied. Defendant has not made a specific showing of need for the government's witness list. And it got the case law. The case law. Defendant puts the cart before the horse and arguing that he needs to know the identities of the witnesses in order to make the required showing of need. And that's what didn't make sense about this motion to me. I was like, this is kind of premature because you have dates to turn in everything, witnesses, certain discovery. Like that's why you beat and confer for all of your dates. But um yeah, it honestly just sounds like this is why some people specialize in civil and some people specialize in defendant, doing defense work for criminal defense, rather. This is why there is a distinction between civil and criminal law. They are not the same. There are some things that cross over, but the rules are different. In civil, you do a lot of this paperwork, but in criminal, it's kind of the same kind of like things that you do. I've done both, so I'm pretty well versed in both. But I would not consider myself, like I told you guys, a criminal defense attorney because I just like my friends can call me today and they'll say, "Can you step in for me on an exam?" or "Can you second chair me on the trial?" or "Can you do these motions to suppress?" I can still do it because that's all the same. But because I don't do criminal like that, if there are new Michigan rules, laws, updates on cases that come out, I don't pay them much attention like that unless my friends that do criminal tell me about it. So it's like you kind of, it's not always good for you to know. I know a little bit of everything, but it's like it's not always good for you to do both, if it makes sense, because you start making your civil come over to thinking it's the same as the criminal. And yeah, so anyway, after a trial date is set, the parties are directed to meet and confer and agree upon a date for disclosure of witness list and impeachment materials, and further to meet and confer in an effort to narrow potential motions in limine concerning prior convictions. Yeah, that's how it goes. I guess I should have kept reading that before I went on my little rant on how things go. But that's what I was thinking. I'm like, this kind of premature, isn't it? Defendant's January 19, 2023 motion for notice by the government pursuant to Federal Rule of Criminal Procedure 12 of its intention to use specific evidence arguably subject to suppression is denied. Everybody put denied in the chat. Denied, denied, denied. Federal Rules of Criminal Procedure 12B4B does not impose an obligation on the government to identify for the defense potentially suppressible evidence or require the government to preview its case. And there's the case law. In order to trigger a notice obligation, the defendant's request must identify potentially suppressible evidence with specificity. Defendant has not done so here. So it's almost like in this motion, you were saying, please give me evidence that may or may not I should be able to do a motion to suppress on. Almost like give me some evidence, like give me the heads up on what I can do a motion on to suppress. Like I wasn't even getting what was going on there, but anyway, let's go to number 4. Defendant's January 20, 2023 motion for pretrial production of evidence admissible to attack the credibility of Brandon Belmonte is denied as moot based on the government's representation that it does not intend to call Belmonte as a witness or offer any of his statements for the truth of the matter asserted. Now that is very interesting to me that they do not plan on even calling Belmonte, but the other day Whitehead was like really ranting about this guy. But we know when we read the government's response, they said they weren't gonna, they at this point in time, they don't plan on calling him as a witness. So anything about him doesn't really matter because the door isn't open for you to even discuss it because he ain't on the stand. I mean, so anyway, the government represents that it intends to offer Belmonte's statement and recorded conversations with defendant only to provide context for defendant's own statements. If the court determines that the proffered statements are appropriate background and not duly prejudicial or excludable on some other ground, Belmonte statements are not hearsay and not subject to impeachment under Federal Rules of Evidence 806. There's the case law. There's some more case law. Prior to trial, the parties are directed to meet and confer on this issue, and if necessary, either party may file a motion in limine. And you file motion in limines when you're trying to, you don't want that evidence entered in, or you can do motion in limines to ensure that some evidence is in. So that those are motions that you always file right before trial. So say for instance, I'm in an auto accident case and my client has a prior conviction. To me, that's not relevant. It's more prejudicial than probative. And so I'm going to file what's called a motion in limine with my case law, my rules of evidence, and I'm going to ask to make sure that they can't bring up this record of my client. Now, if I get up there and I open the door, then it'll change everything. That's what happened in the Tory Lanez case, where some of that evidence wasn't going to be admissible, i.e., that whole conversation with what's her name, Kelsey, that wasn't going to be admitted. But then because the defense went a little bit too far, they opened up the door. But it sounded like her statement was not admissible, probably because they did a motion in limine. So that's what a motion in limine is used for. And that's it. So then the clerk of the court is respectfully directed to close these motions. Thank you so much, y'all, for these super chats. I appreciate. Thank you. Thank you. Butchie's wife and Cynthia Harrell. I appreciate it, y'all. It's 412 of you guys in this here chat. Y'all, please hit this like. Please hit this like. Thank you. Thank you. Thank you. Thank you to everybody. I'm sorry I'm missing the I've been reading, I get into this stuff. This is what I love to do. So then I don't even hear see a lot of the stuff in the chat. And then people inbox me and they're like, hey. So I apologize in advance. You said denied in capitals. So that's that, y'all. So now we got to talk about Miss Anderson. I'm going to do a couple of your comments. We're only 20 minutes in. We still taking our time. That judge is not playing with his tail. He should just pack his toothbrush and plan for peace, Pam, I got to do a praise dance. God don't bless no mess, period. He needs to quit and shut his mouth. Yes, it's free. You see my mods, hit that like. Get me in the algorithm so other people can enjoy some of this commentary. And so before I get to the next person, I am going, but the next case, everybody say next case, next case. So before I get to the next case, where it's Anderson, I want to do a little background because we haven't talked about her in a long time. And for those of you that don't know, when you keep hearing about this $90,000 that's in the indictment, and that was brought up during the press conference. So a lot of us learned about the $90,000 when Whitehead had the press conference when his church was robbed. So a couple of days later, he did his big press conference. Well, apparently he was already a hot topic in the New York area. So they had all of these different articles even before that robbery. We didn't know about him because he was like nobody does, Midwest and all of that. We didn't know who he was. So one of the reporters said, what about the $90,000 case that you took from a parishioner? And he's like, that's not true. I have lawyers handling that or whatever. So he addressed that. To that, that it wasn't really addressed. He just kind of mentioned, he acknowledged that he knew about it, but he really didn't talk about it. He kind of went away from it and was like, and we got a victory today. And the victory he was talking about was because the victory he was discussing was allegedly, I guess, this lawsuit was filed in 2021. Whitehead had never responded to the lawsuit at all. So what Anderson's attorney did was try to default him. Well, apparently under their rules in New York, they have a lot of rules and procedures. So under their rules, her attorney didn't do something right. So the judge denied their motion without prejudice to refile it for procedural reasons. Mind you, Whitehead did not have an attorney at all during that time, just to refresh some of your recollection. Didn't have an attorney, but he was on there like, they told us we got a victory today. Like, you got a victory, but you weren't even in the case. Hadn't entered an appearance, hadn't none of that. So we know his attorney that has been a part of all of these lawsuits. This attorney at that time was going on YouTube, and he went on at least 2 channels that I saw where he was going over the lawsuit about with Anderson. He was going over the lawsuit. And he was going over the lawsuit as if he felt like he wanted to help Anderson. He also emailed Anderson's attorney asking can he jump on and help, and said, I don't want anything out of you. I think there's some federal claims that's here too that we can do civilly, because I do credit stuff and all of that. He went over the email between Anderson's attorney and him, where Anderson's attorney basically said, nah, bro, I don't need you to help me. So he went over it, basically telling Anderson's attorney all the deficiencies that he felt was in that complaint. That's what he did. Then he said, but I can jump on and help you and be co-counsel. Anderson's attorney responded and did his own case law. This was all on the email. He put it on somebody's YouTube channel. Anderson's attorney responded and was like, I don't agree with you. I think you're wrong. I don't need your help, basically. So he had a couple of people on YouTube like, oh, Anderson really needs your help, blah, 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 blah. You seem like you would be beneficial. So if you guys recall, there was a guy that came on my channel some weeks back, months back, and he alleges that Whitehead owed him money because he was his campaign worker. And so I was waiting, and I was hold on one second, y'all. Okay, sorry about that. Had emergency text. Oh my gosh, I can't stand when people talk about they going to the hospital. So, anyways, when he needed help, I had actually reached out to the attorney because I said, okay, well, if Anderson don't want you to help him, this was back before, I really knew who he was. And I was like, well, if Anderson, if they don't want to use you when you're looking for somebody to help, then I may have somebody to help. So then he said, like, send over the complaint. I never sent him the complaint because something just wasn't really vibing with me. So I never sent it over. I was like, you know what? I got friends in New York. I'll just, get you somebody that maybe able to give you some direction in New York or whatever, because I didn't know their procedures like that. I know it now dealing with his cases. I probably could practice over there. So he was like, okay, send me the complaint. This was on a Thursday. On Friday, he filed that lawsuit against Reed and Jives. Never said, hey, I can't represent nobody because Reed, I'm representing Whitehead. So that's how I found out about him kind of switching over and representing Whitehead. And I was kind of mad. Like, you can ask my husband. I was like, what type? You could have just said it's a conflict. Like, how do you just say send it over like you gonna help this guy? But then I didn't do it. Use my discernment. But the next day it just tripped me out. But anyways, that's just a little story I have been keeping about that whole situation. So anywho, he starts representing Whitehead on all these lawsuits, as you guys see. So he comes in on the Anderson case, and of course, he files a motion to dismiss. Now, all of you guys that have been following my channel, I want you guys to say in the chat, what do you think? He tried to file a motion to dismiss as to Whitehead. What do you think his argument was? Why the case should be dismissed? So on Anderson, the first thing he did when he entered was he filed a motion to dismiss. He had one specific reason, No, he had a few reasons, but the first reason, I bet you guys can guess what it is. And the other three, he basically said what he told Anderson's attorney in the email. Like, you really ain't stated claim. You said fraud, but you didn't do it with specificity as the court rule or the law makes you do. He said those type of arguments, and he did a motion to dismiss. He also, remember on the Anderson case, there was also a claim against Lamor Whitehead Inc. as well. So he also filed a motion to dismiss on Lamor Whitehead Inc., just like he did with Lamor Whitehead. Let me see if you guys was able to figure it out. Let's see. Thank y'all for all the super chats and all of that. No. So what he said, y'all, I thought y'all was really gonna get it. He said that the case should be dismissed because he was never served. No, not never served. It was lack of jurisdiction. He was basically arguing that he does not live in New York. He lives in New Jersey, which is interesting to me because you file all these cases in New York. But then when somebody files one against you, you like, I don't live here. So you don't have, he basically said he doesn't live in New York. He doesn't have enough contacts with New York, even though you got a whole church in New York. You filed at least 3 lawsuits for defamation in New York, claiming it affected your church in New York. But on this case, he basically said there's no jurisdiction at all over him. So he said he got so many cases. Listen, Anderson is the one that as you guys know, that's the $90,000. That's also the one where um we have the indictment as well. So anyway, so he filed one saying lack of jurisdiction. And then he also filed one, let's see. He filed a motion to dismiss. You see his motion sequence number 003. He filed a motion to dismiss, basically saying this. Plaintiff, this was back in September 15, 2022. Okay. This was after he went on the YouTube, said all this stuff about said all this stuff about Whitehead, wanted to represent people against him, said he predicts he'll be locked up or whatever by the end of the year and all that other stuff that he said. He decides in September he's going to start representing him. And I believe this was probably one of the first cases. And he started representing him on this. So the intro says plaintiff Pauline Anderson filed her verified complaint on September 10th of 2021. So as you guys see, this is almost it is a whole year later. This is almost a whole year later by 5 days, a whole year later that he responds to this. So it lets you know that honestly, it was that robbery that almost gave him the heads up to go ahead and try to do something with this, because we've seen other judgments he has against him. So it has on September 10th, 2021 against defendant Lamor Whitehead Inc. So that was the second person on the pleading, the second entity on the pleading. Unfortunately, this is the excuse, y'all. Unfortunately, due to excusable neglect of LWI's officer to update its service of process address with the Secretary of State of the state of New York, LWI did not receive notice of the lawsuit after LWI was served process via the New York SOS. See, he can't say he wasn't served because under New York law, you're able to serve the Secretary of State for your corporation or your company. However, upon LWI hiring counsel and obtaining a copy of this lawsuit, it seeks an extension of time to appear under the provisions of NYCPLR Section 3012D to assert its meritorious defenses herein. Plaintiff's complaint is based on duplicitous claims based on legally insufficient allegations. Plaintiff purported causes of action are for fraudulent misrepresentation, conversion, breach of contract, unjust enrichment, and constructive trust. All the claims fail. So that's basically what their argument is. So they're trying to ask the court, because you don't have this same I don't live there, I wasn't personally served like Whitehead has as a person. His corporation, you can it's perfected service when you serve the Secretary of State. So now you pretty much got to come up with an excuse as to why you didn't respond and it was properly served. This is a whole year later. A whole year later. So of course, both these motions that were filed on September 15th of 2022, which was Whitehead personally and his company to dismiss, Anderson responded to. So he responded to both of these motions. As to Whitehead, what's happening now is it went over to some type of a special, this is some type of special person, I guess, that does a special referee, JHO, serving as an uncompensated volunteer judicial hearing officer pro bono who waives any claims of compensation. And there somebody's gonna do a hearing coming up on whether he was properly served, which is gonna be very, very interesting because this has been a defense in at least a few of the documents we've read together, especially in Connecticut. Remember, he has tried to do a motion to dismiss on those buildings saying that he wasn't properly served. And yeah, so that hearing has to come up on whether he was properly served. Um, hold on. Then so that's that one. So you guys can know there's a hearing come up to see if he was properly served. Then we have, hold on. Then we have on the second motion, which would be to dismiss that Whitehead filed in September, trying to dismiss the company. We have this. This is, let's go over the attorney's affidavit, and then once we go over the affidavit, then I'll tell you. Of course, he filed a motion attached to his motion. He did an affidavit. So he basically does this as an affidavit in opposition of the motion. So he gives his factual and procedural background. So anybody that's not familiar with what I'm talking about, this factual and procedural background should let you know. The facts of this matter are set out in further detail in the verified complaint dated September 10th, 2021, and the exhibits attached. Specifically, defendant Lamor Whitehead was plaintiff Pauline Anderson's pastor at Leaders of Tomorrow International Church in Brooklyn, New York. Miss Anderson's first attended the church in person, and then after COVID started, she attended several online services. Miss Anderson met defendant Whitehead through her son, Rashid Anderson, who volunteered for the church and for whom Mr. Whitehead has similarly helped in purchasing a home for himself. As her pastor, Mr. Whitehead placed himself in a position of trust for Miss Anderson, culminating in her reliance on his promises as a man of God, and due to his prior acts of helping her son through several conversations with Miss Anderson, Mr. Whitehead fraudulently induced her to invest her entire life savings of $90,000 in his sham real estate company, LWI, under the guise that he would use his alleged expertise in real estate to buy and flip properties, and that she would see a return on her investment as well as a monthly subsidy. This agreement was an exchange of money for services, not real property itself, as incorrectly alleged by defendant. The complaint succinctly summarizes the times, dates, and details of the false promises represented by Mr. Whitehead and the numerous conversations held between the parties that ultimately led plaintiff to release her money to him. After realizing that she did not want to do business with Mr. Whitehead, Ms. Anderson sought to get her money back from him. He later indicated in a text exchange to her that the money was already invested and that he could not help her until his campaign for Brooklyn Borough President was complete, even though he is allegedly not a resident of Brooklyn, New York. Phone text exchanges annexed to the complaint as Exhibit B and C provide further details of the agreement and the fraud perpetrated by defendant Whitehead. Instead, Mr. Whitehead allegedly used Ms. Anderson's money as a down payment to purchase a lavish home in the wealthy neighborhood of Saddle River, New Jersey, valued at $4.4 million. And according to a recently filed criminal indictment against him, so he basically responded recently, like in January. So he was able to add this as well. So, according to a recently filed criminal indictment against him to allegedly purchase thousands of dollars in luxury goods and clothing, he only paid her one monthly payment of $100 towards her investment. The summons and complaint in this matter were properly served on defendant Lamor Whitehead Inc. by service in the New York State Secretary of State on October 15, 2021. An affidavit of service was duly filed with the court on November 9, 2021. After all defendants failed to appear or file an answer within the requisite period of time, plaintiff caused the office to serve defendants with a default notice pursuant to CPLR 3215G. An initial motion for default judgment was filed on February 7th. That motion was denied without prejudice to refile on July 27th, 2022, due to procedural failure to file a proof of service. So remember, that's what I was telling you, that they filed to default because it had been so long and he never answered. In July, remember, this is around when the robbery happened. So he learned at that press conference he had where a reporter said, well, we see they denied the motion for default. And he was like, yes, we got a victory today. We got a victory. So on or about September 15, 2022, LWI appeared in this matter by filing this motion to extend time for it to answer and pre-answer motion to dismiss. So you only have a certain amount of time to file a motion to dismiss and to, and so he had to ask in that for the incorporation, he had to ask the court, can you please extend the time for me to answer? And he made the excuse, as you saying, that the address was never changed and all that, so it shouldn't be considered proper service even on Secretary of State. However, prior to making an official appearance in this action, defendant Whitehead, the LWI's sole known officer, appeared publicly on several occasions to address this lawsuit. Remember, I said just be quiet. In a public interview on a YouTube channel that occurred on or about July 29, 2022, before officially appearing in this matter, defendant Whitehead admitted the following statement supporting plaintiff's claim. Question: now, what about these rumors about that were accusations that a former member who tithed over $90,000 to you at one time? Do you know about that rumor? Answer: it was not right. Yeah, so I'm glad I'm going to clear this up. There was never a tithe to my church for over 90,000. All right. And if you the way you want to make the court papers look or whatever is asinine. There was a young man that was in my ministry that was in real estate company where we were doing investment. His family invested the money, but yet you can't take the money for 2 years. And in all actuality, right, he was down on his luck, him and his wife. And I actually fronted him back $40 to $50,000 out of that, right? So when he got upset with me in the ministry and he was mistreating my members and being mean, and I had to get at him, he left the ministry and said, quote, you know what, give us the money back. And I said, no, it doesn't work like that. It doesn't work like that. The agreement, emphasis added, is if you pull out, you lose a heavy percentage. That what it is when you can't just pull out. You can't pull out or you're going to lose a heavy percentage. So they turned that whole paperwork around to make it seem like that they tithed it to my ministry, and none of the paperwork have no ministry on it. It has nothing to do with the ministry. They just put the ministry so it could sound good. So I didn't take no money from nobody. It was business. So they have that in the courts. And my lawyers are handling that, and that's what it is. People sue people of success. That's what, don't you? I don't know if you can attest to that or not. So that was him on the Tasha K. When Bishop Whitehead was on Tasha K and did his exclusive, that's where they got it from. How ironic. Oh my, I didn't know that's where they got it from. Remember at first that was around when Tasha and Larry, I guess, was cool. So yeah. Y'all hit that like button. It's over 500 of you guys in the chat. So basically he said on here, he acknowledged there was an agreement and the money, and he knew about it because you decided to talk about it on Tasha Gay. So anyway, on July 31st, 2022, defendant Whitehead is reported as again publicly acknowledging the content of the suit in a sermon at his church, mischaracterizing plaintiff as a quote liar and stating of the lawsuit, quote, that's what the enemy wants you to believe. On May 23rd, 2022, defendant transferred the title of his home for the consideration of $10. That property was then immediately listed online for sale with an asking price of 2.99999, blatant attempt to dispose of assets before judgment could be rendered in plaintiff's favor. And doing so, Mr. Whitehead attempted to render himself judgment proof to prevent a lien or attachment to the $3 million home that he owns. As referenced above, Mr. Whitehead has gained some notoriety over the last year, including a recent arrest by the FBI in December 2022 for criminal wire fraud, attempted extortion, and making false statements to the F, the B, and the I. Upon information and belief, part of his criminal indictment was for the fraud complained of herein, committed by Mr. Whitehead against Ms. Anderson. A copy of defendant Whitehead's publicly released sealed indictment is annexed here too as Exhibit A and made a part hereof. We've all seen the indictment several times, so I'm not going to pull that up. His criminal matter remains pending before the federal criminal court. Plaintiff filed a second motion for default judgment by order to show cause in addition for equitable relief or preliminary injunction and attachment on September 23rd, 2022. That's motion sequence number 004. Remember, this is motion sequence number 003 that we're talking about. So they number as the motions have been filed. The first motion would have been the plaintiff's motion for a default. The second motion, 002, would have been Whitehead's motion to dismiss him based on lack of jurisdiction. 003 is his motion to dismiss the company based on saying that there weren't claims and he should get an extension of time and all of that good stuff. So in order to keep up, they have to do the motions in sequences. Thereafter, plaintiff filed a motion pursuant to CPL 2201 for the court to retroactively extend the time for service of plaintiff order to show cause and deem it served non-pro-tunc. I got everybody calling me. Wait 1 second. One second, 1 second. Okay, doing it non-pro-tunc. And non-pro-tunc is basically, it's a Latin term. If you do anything in the law, you know it's Latin. And it means now for then. So it's basically asking you to change back to an earlier date of an order, judgment, or filing of a document. So you kind of go back and retroactively, so for the court to retroactively extend the time for service of plaintiff's order to show cause and deem it served non-pro-tunc. That motion is also pending before the courts. For the reasons stated in plaintiff's memorandum of law in opposition filed simultaneously with this affirmation, defendant's motion to dismiss must be denied in its entirety. So that is the affidavit. Of course, the motion will have all the laws as to why they believe that that Whitehead's case should not be dismissed and blah blah blah. So there's an opposition. So the court issued an order on February 1st, and this order is based on sequence number 003, which again is Whitehead's motion to dismiss his company. And this is the court's response. Now, remember the first one we talked about against Whitehead, there's going to be a special hearing to figure out if he was personally served or not. But this response, this order is for 003, which is against the company. Anderson v. Whitehead, motion denied. Pursuant to Uniform Rule 202.27, no appearance or movements. So, as it pertains to the company, this is what the court had to say. So, let's go back to these. All right. And if it's any questions y'all got, you guys, if I was moving too fast, let me go back in the comments. Thank you all for the super stickers and chats. And I appreciate it. I'm so behind on these chats. Let's see. We're still under an hour. We're doing good on time. Abraham said it's like reading about Trump again. It never gets old. Bitch, you said 10 toes down, denied. I can't. Yes, yes. Thank you, thank you, thank you for all of your support. I appreciate it. Thank you guys for looking out for everybody, for me, because I'm not paying attention to the chat. I appreciate all of the super chat stickers, everything, all the love, all the cash apps, all of the PayPals. I appreciate it. You, you guys were fooling in this chat. Oh my. Oh goodness. Did you say your bubblegum frame? You guys are brutal. Okay. What's the question? Thank you, Tyra. I appreciate it. Again, Jay Wash, I appreciate it. Yes, I'm in Michigan. Thank you so much. Yes, he's on the other side. If you guys were able to see the last video, well, not the last one, before that, when I went over the response from the Reed lawsuit, you'll see his attorney also put snippets in there from what Whitehead's attorney said about him. So, yes, welcome, welcome, welcome. Thank you, thank you. What else we got? He has a serial history of shorting folks or not paying them. This has followed him practically his entire adult life. He's infamous for this. Oh wow. You recall the interview, yes. And the crazy part is I think he has a motion. They gave him some ridiculous date sometime this year. He should be having some type of resolution, hopefully, to his case. Uh, mm, yes, you had guessed it. You guys are smart. Okay, so I must have missed it. I'm sorry. You guys guessed it. I must have missed it when I was going through the chat. Yes, make sure you subscribe to this channel. And goodness, yeah. He got you said his lips. Oh gosh. I want to know. Toria Williams asks, I want to know, how is he paying a lawyer when his house in foreclosure? He has civil cases, federal cases. The church is not in the building. Where is the money coming from for this lawyer? I don't know, but his bond condition did say that he had to get employment, so maybe he got a job. I don't know. He said he has several businesses, but you said he gets himself in trouble, even if it was. I know it wasn't. You can't spend campaign funds on ugly suits you didn't pay your staff. Oh gosh. The chat is yes, Maria. This chat is showing no mercy on the bishop. Oh, you got your Abraham. I can't put these three people on here because they'll unmonetize me for those names. I put them on the title. They like, no, ma'am, no, ma'am. You're not getting monetized. No. Yes, he did run for borough president. Y'all, if you're just coming in, if you guys gotta hit that replay because we went over the indictment. Well, I'm starting to get these doggone cases confused. We went over the criminal case. The judge denied four of the motions. And then we just went over an update on the Anderson case that's still going on and also a part of the indictment. Yes, you're going to have to go back to the replay. I'm trying to find, Dev, I'm trying to find your question. Um, when he says the man of God, it makes me laugh. He made his own self a bishop. A man of God does not get out of prison and continues scamming people. I want to see him in handcuffs and keep thrown away. Abraham said, do you know him or something, Abraham? Would you like to give us some insight? Because you sound quite familiar with Mr. Whitehead. Do you have any insight here? He said being in prison and sprung on a technicality only emboldened him more. He with all caps. He was plotting while and just put his plan in motion once he got out. You guys are, and the fact that he's still, and you guys are all a part of my staff now because you guys are some thinkers here, and the fact that he still has members is beyond me. Yeah, it's interesting choice. But see, that's what we were saying when we started this. If you guys, some of y'all have been riding with me since I started and had 50 people. And when we started this and we were talking about this case, it was like, oh, we were very empathetic. I thought we were like, give these people their money back. That's all we asking. Like, if you owe them the money, give them their money back. That's all we were saying. And you turn around. Thank you, Lay, for the super chat. I can't believe what I'm hearing. I wonder why this isn't viral on YouTube with the big YouTubers who want to spread unfounded rumors of lies on me, smear campaign, and jealousy. Thank you so much. I appreciate it. I'm trying to find your question, Dev. I am so behind on it. I can't find your question on here. Huh? You're trying to yell at me from the other room. This is real ghetto. Yes, denied. And then just to give you guys a real quick update. So we know on March 30th, there's going to be a trial in bankruptcy court. It's going to be a hearing. They have dates for witness lists. They have dates for right now they're doing discovery. And from what I've seen that has been filed, glory of God is they've done like what we call request to admit. So it's like admit you ain't the trustee. Admit, I'm just making this up off the top of my head, but that's kind of how request it for admit. You formulate it in a way where they have to admit it or deny it. So they're doing what we call discovery, where they're asking him to produce certain documents, and most of the discovery for Glory of God and Moses are the same. So I'm assuming they're kind of, they kind of working together somewhat. It appears. Thank you, Tyra, for the super sticker. Tracy said, how many cases does he have? That's a very good question. I can tell you the cases that I know of. I know there is a foreclosure case on his house in New Jersey. I know there is a foreclosure case in Connecticut. I know there is this Anderson case. The campaign worker case. He's filed cases against Larry Reed, King Jives, Miss Jones. He's also filed some cases claiming some issues with his credit. It was a case against the BMW dealership or something like that, or Benz dealership, wherever he got his car from, that he's saying that they did something improper with his credit. He has this indictment. I don't know how many that is. So yeah, and we're pretty much covering all of them. Oh, then he got the Glory of God case. That's landlord tenant, and now he made it to bankruptcy. And it's also a part of a foreclosure case as well. It's a lot. And then I made the stupid statement that we're gonna follow all of these through. I didn't think I was gonna be doing this 6 months later, and that he was just gonna keep getting cases. So I'm trying to be a woman of my word and go through all. Wonder why he says he's a chief, why he never says chief apostle anymore. Yes, Pam you. That sounds good. I like that has a ring to it. Amen. It has a ring to it. I like that. You guys are all a part of Pam you. Toria said he can start selling those name brand clothes. He has to drop the name of every time he goes live. He's not going to be able to wear them or take them with him. All right, y'all. So, right. I didn't know he was going to have all these cases. I was really thinking, like, and then we're invested now. So now we're all like, what's going on in that case? Pam, any updates? People sending me articles. Oh, then he had, remember when he had the building, he also filed all of those eviction notices for all the people in the building. So he filed them, but there was never any responses, and I think the court just dismissed all of those in December. So those aren't any no longer pending. But we're just trying to wait for some resolutions here. But that's it. So anyway, hey Pebbles. Poetic said it's a quadrillion cases out there. So anyway, I hope you guys enjoyed today's live. You know, we try to get in a good hour. So we were able to go over the Anderson case. We're able to go over the indictment case and where the bankruptcy case is. So as always, we will be on it since I said we're gonna be on it. And wait, wait a minute. Trying to stop share this so you guys can just see me. Thank you, Deborah. I appreciate it. Thank you for the super sticker. Thank you, everybody, for your support. I appreciate it. You guys are gonna bring tears to my eyes. Thank you all 500 that was here today on this live. Your participation in the chat. We're just one big family over here, one big legal family. So of course I'll be following everything that's going on with Whitehead on all ends, and we're going to continue to dissect this. Yes, we love you and we appreciate you. Thank you, thank you, thank you. Oh my. You're welcome. You're welcome. You're welcome. You're welcome. All right, guys. So we are out of here. I got 50 phone calls to answer before I go to bed. Until next time, I love each and every one of you. Everybody stay safe. Thanks for rocking with me.